All rise. Court of Appeals, Division 1, now session.
Good afternoon. You may be seated. We are here this afternoon on our case number, a series of consolidated cases, the first of which is 1 CA UB170004. Good to see you all again. Each side's allotted 20 minutes for your argument. I see that we've positioned each other in this fashion with the state on the appellant side and Probo and Amiki on the appellee side. Each of you get 20 minutes, and we understand that you've agreed to, each one of you separately is going to divide your arguments in half. So you may do that. We're not going to interrupt you. You're on your own to stop at the appointed time. If either of you would like to reserve time, you are in charge of keeping track of that for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We have read all the briefing, and we've looked at the spreadsheet. Thank you for responding to the spreadsheet request, and we've also reviewed the amended one that was filed a few days ago. We would ask the state, I'm going to say it now so that I don't forget to ask for it at the end, we'd be grateful to you if you would please lodge with the clerk of the court and serve on opposing counsel a digital copy of that spreadsheet on a CD or on a thumb drive, or however it's best, easier for you to do. So with that, we've also discussed the case in our conference today. So with that, you may proceed. Have you decided among yourselves which sides to go first?
Let's get the pro bono first.
Okay, let's get the pro bono lawyers first.
Thank you, and may it please the court. My name is Julia Wagner. I am appointed pro bono counsel, and my co-counsel is Andy Guyana. And I will be addressing the procedural due process question that the court presented. There was two issues. One, is there due process violations or other rights that might have been at issue here? And then my co-counsel will kind of be addressing the sanctions or the remedies section. To start, it seems that we agree on a lot of the due process violation sections of the brief. We both agree that the Matthews v. Eldridge factors are going to be what the court should take into consideration. I think the overall issue that we have with the due process question is whether or not we can make, or the court can make, a blanket due process violation that all of these 500 and some appeals that were delayed, whether or not the court can make a blanket finding that a due process violation occurred. So in looking at the factors, at least from the pro bono side of it, the first factor the Matthews v. Eldridge case is the private interest that will be affected by the official action. At least in Kelly versus the Railroad Retirement Board, which is a Third Circuit case out of the Third Circuit, they looked at specifically whether or not a delay in the entire process could be considered in a due process violation capacity. And in that case specifically, they said 4 years was a problem. And there, in that case, it was retirement benefits. The initial finding was that the claimant was not entitled to those benefits, and then she waited 4 years before she had any final determination. The Third Circuit said that in and of itself was a due process violation. They specifically looked at the process and said the retirement board had the ability to implement procedures. They had the ability to implement oversight over the appeal process, and they chose not to. And because of that, there was a due process violation in that case. It's just one factor to look at, but we believe that the private interest that will be affected by the official action in this case, at least some of these cases will have due process violations. It's just a matter of looking at fact-specific, what was the amount of the delay, things like that.
It seems from the briefing and from our own processing of a number of these cases that the panel individually has done, sitting with other judges over the course of the last few months, as the briefing has established, there are most of these cases, the claimant is entitled to no relief on the merits. In most of these cases, this court will ultimately deny the application for appeal. There are a handful of cases, other cases where the claimant was wrongly deprived of benefits, and of course the delay exacerbates that to a greater or lesser degree depending on the delay. And we know that the briefs go back and forth on that point. Isn't there something to be said, though, for the fact that across the board, the claimants were abused by the utter lack of concern by a significant state agency that is set up to provide services to the disadvantaged in a case like this?
I think, Your Honor, absolutely. The egregiousness of the delays in this case certainly rise to the level of some type of violation, whether it's a due process violation or some other right. But I think you do have to look at the individual cases to determine specifically due process, because it does require a fact-specific determination. But absolutely, there could certainly be a situation where there is a blanket finding of I guess I don't want to say a dilatory attitude, a dilatory type of a finding of bad faith.
Well, the state argues that at most the worst that what happened here is bad conduct, egregiously bad conduct on the part of one employee. Is that what we have here, or do we have a situation where the state allowed that bad, by failing to pay attention to that bad employee, allowed the situation to develop?
I think it's definitely the latter, Your Honor. It's one thing to blame this on a rogue employee that didn't do her job, but she was allowed to not do her job because there was no oversight, and that is a department systemic problem that goes beyond just an individual who didn't do her job. And we have, over 500 appeals that were not transmitted to this court within 30 days within the statutory guidelines. So certainly that fact, the fact that it was even able to happen, lends itself to a due process violation on a blanket level.
So you're saying that there are factors of commonality that affect all of these applications that were not timely transmitted?
Absolutely. That and that commonality is the delay and the systemic.
And that commonality, including the systemic failure you're about to again reiterate, would be sufficient to allow this court to find, if appropriate, a violation of procedural due process, applicable to all of those cases.
Absolutely, Your Honor. It certainly goes towards the first Eldridge or Matthews v. Eldridge factor, and that will affect every single one of the delayed cases beyond the 30 days that were transmitted to this court. The second factor, again, to the extent that there were specific cases where transcripts were purged as a result of the delay, those cases obviously are going to need to be sent back for either rehearing or it certainly lends itself to, in those cases, that due process violations did occur. And then finally, the factor that the state has no interest in delaying the transmission. Obviously, they have agreed, we all agree on that it's in the best interest for ADS to transfer these cases within the 30 days, within the statutory guidelines. I'll turn it over to unless the court has any questions on the due process
Just
substantive issue.
one question. You're obviously familiar with the decision that was issued by another panel of this court relative to the order to show cause proceedings. In addition to the administrative directives contained in that decision, can you think of any additional suggestions that you have that would assist the department in complying with its obligations under the procedural due process construct you've been talking about?
Tying it into the procedural due process, I think based on the chart that was provided by the department, there is a whole category of claimants that overpayment is at issue. And so fashioning some type of remedy for those people in the sense that if that claimant can appeals this overpayment determination, directing the department to consider the length of delay in whether or not it would be against equity and good conscience to waive this repayment, and that's the principal amount.
To waive the principal?
Yes.
Yeah, the state makes that point, and maybe we'll talk about that in the next section. But I've seen a number of those. I've seen a number of appeals from those cases, and boy, those hearing officers are pretty firm in enforcing the debt. But thank you.
Other than that, my co-counsel will address the remedies.
Thank you, Your Honors. May it please the Court. Andy Gaona with Coppersmith Brockelman, pro bono counsel as well. I'm going to address today the second question that was posed by the Court, which is what, if any, specific actions, which is the wording the Court used, can or should be taken in response to ADES's conduct. And I think the framing of that question is important. And Judge Johnson, your question earlier hit the nail on the head, which is that we're not here just talking about the acts of a rogue employee. We are talking about an institutional failure on the part of a critical state agency that administers essentially subsistence funding programs for the most needy Arizonans. It's with that gloss that we've tried to approach what appropriate remedies there may be in this case for ADES's misconduct, and I'll just refer to it as the department for short. I think the real disagreement here, and I'm not sure that there is a disagreement, is on how the court should deal with the effect on itself. And that is that while the applicants have suffered a great deal here, the ADES's and the department's delay has really, I think, as Judge Swan put it at the OSC hearing, has really upended the operations of the court. I know the panel in the OSC case addressed this in part and declined to assess any sort of sanction of court costs against the department for reasons that are stated in that I don't think necessarily apply here, mostly because the scope is so much larger here. And the OSC panel specifically deferred to this panel in terms of addressing the larger problem versus the strict noncompliance with the administrative order.
Although our role is to decide these cases. That's our job. I'm a little concerned about a self-referential sort of remedy. Our real purpose is to make sure that the people of Arizona get access to justice on a fair and equal basis. So my concern goes much more to the people who have been disadvantaged than to those of us who have simply had to hunker down and do our jobs more quickly than we might have had to if these cases had come to us timely.
And I agree with that, Your Honor. I think part of the problem here is that, as Judge Johnson pointed out, a lot of the delayed cases have already, the applications have already been denied. They're no longer before the court. And trying to fashion as is pointed out in our opening brief, there are a number of difficulties, not the least of which is jurisdiction at this point, I think, in fashioning these individual remedies.
Well,
I think what we can do going forward to ensure, as you put it, Judge Swan, that all Arizonans have an opportunity for equal access to justice is to do everything we can to ensure that this never happens again. I'm not ruling out the possibility that those who were affected by this, whose cases are no longer before this court, don't have a remedy in some form.
Well,
and
let's talk about that. What
Sure.
forms can you envision? Because while you're right that the court has disposed of many of these cases, and we certainly couldn't wait for this process to start, we didn't want to compound the delay that everybody faced, and we got to work. But do you believe if there is some deprivation of due process, even on a claim that where we denied an appeal, if there's some deprivation of due process getting to that point, that the person so deprived has a remedy, whether within or outside of this proceeding?
Within this proceeding, Your Honor, I think is less clear. Certainly outside of this proceeding, if under the Matthews construct, I suppose it's possible that somebody who suffered a due process violation could establish some liability under a 1983 theory or something along those lines, and that was suggested there. I know that's a high bar. It will be difficult to prove, and it's frustrating from the perspective of trying to fashion a remedy.
Part of it is a high bar.
Well, I'm just, in terms of against whom the relief can be sought, we have, there are 11th Amendment problems that a 1983 case would have, and who's the officer against whom it's brought. Obviously, there's indemnification, but there are limits, and having litigated qualified immunity cases, qualified immunity always comes into play as well. It is a high bar in that sense in overcoming qualified immunity. As I think we're seeing that qualified immunity develop out, that is becoming increasingly, making it increasingly more difficult for 1983 plaintiffs to succeed. But I think there is a solution, at least for those applicants whose applications were granted, where there are applications for appeal pending, and I think some panels of this court are already doing it, which is utilizing the pro bono program and appointing pro bono counsel to brief this precise issue on the particular facts of each of those cases to determine what, if anything, in those cases where there is merit to the appeal enough that this court saw fit to order further briefing and will consider the merits, that is the correct interim step, at least, so that on the facts of the individual cases, as Ms. Wagner noted, the due process violations can be evaluated and appropriate remedies imposed by those particular panels.
Well, let's assume for a moment that we had a 1983 case here, and I know we don't. But would there be any difference between these cases factually in terms of the actual deprivation of due process? Wouldn't the only difference be in terms of what the damages might be?
That's possible, Your Honor. I haven't thought through fully prosecuting a 1983 claim on behalf of one of these applicants, but there may be as Ms. Wagner suggested, that it may be enough that the delay caused a due process violation. Now, that's going to depend because we don't have uniform amounts of delay. What amount of delay was reasonable? You could have a due process violation on that finding alone. Now, in the particular circumstances of a person, it may be the due process violation, I think, has the potential to be more egregious. Now, that may go to the violation itself. It may also go to damages, as you point out.
Well, and this is an intentional delay. This is not an we're overworked delay, as occurs in other cases. This is an intentional act by an unsupervised rogue employee. Let me ask you, what could we do? What could this panel do along the lines that Ms. Wagner suggested to urge or effectuate a waiver of some of the overpayments that are due? Some of these are very long periods. It's good the state's voluntarily going to waive the interest on most of those, but this money in most of these cases is long ago spent.
That's correct, Your Honor. And I think the waiver of interest is an important first step. I think that should be, while the department has said it's doing that, I think that should be in an order. I want to say that from the outset, that it should be ordered to waive the interest. And as to the principal, ARS 23787C does give the department discretion to waive principal if requiring its repayment would be against equity and good conscience. And I think on the facts of this case, we have that, and there's already a statutory structure whereby ADES could be doing that on its own. I don't know, as you pointed out, Judge Johnson, in the agency, I think that statute is very rarely successfully invoked by a claimant.
I have two questions for you on that then, and it may take us beyond our allotted time. But first of all, there are many categories of cases here. The largest category, I believe, is unemployment benefits. If the department waives the principal on unemployment benefit repayments, what happens to the employer's account?
And Your Honor, this is a concern that was highlighted in our opening brief, which is that the employers in this process have due process rights. They have not appeared in this proceeding to date. I know in some cases they are starting to appear as a result of this. But it's my understanding that the employer's experience rating gets charged. Now, if there's a complete waiver, the department may be in a better position to explain how they treat the experience rating for the employers. But it has at least the serious potential to adversely affect those employers who again had the right to appear in the agency. Sometimes they do, sometimes they don't.
So the agency has put us in a position, if we afford any remedy of all, of hurting one innocent person or hurting another innocent person.
That's entirely possible, Your Honor.
Okay. And let's say for a moment that weren't the case, and that it were possible to fashion a remedy that would have no innocent parties harmed. What's your position on our ability to do anything outside of the 6 cases that are identified in the caption of this proceeding?
Your Honor, I think that this court, in its supervisory capacity and in exercise of its inherent authority, has a great deal of discretion. If it's not appropriate in this context, the docket in the order to show cause case is still open, or this court could, of course, open a separate docket in order to address this if there was a question about the jurisdiction of this panel in these 6 consolidated cases to afford any sort of broader relief. Because, as this court's cases have said, inherent authority is largely unwritten and is justified by the facts that are provided in order to justify it. If there was any question, I think that would be the correct approach to take, where we've borne these issues out now, but we could have a separate proceeding if we needed to ensure that the record was clear as to what was being addressed, and to the extent that the state is due any process, it would receive it at that point through that proceeding. Because we're dealing with a small group of cases here, I think there are certainly no constraints other than whatever the court chooses to impose on itself in terms of the remedies that could be imposed in those particular cases. But from a systemic point of view, any doubt about jurisdiction in those other cases could be resolved either through the existing order to show cause matter or by opening a new one, I think.
All right, thank you.
Thank you, Your Honors.
afternoon. May it please the court, my name is Joanne Falgett, and I'm representing the Arizona Department of Economic Security. I'm here with my co-counsel, Carol Savati, and I will be addressing the due process issue, and she will be addressing the remedies issue as we go forward. I just wanted to quickly correct a misstatement. Ms. Wagner had referred to 500 appeals delayed, but by my count, there were approximately 360 that were actually delayed. Many of the ones on the chart that the court sent were, in fact, timely submitted. It's just that they were filed as this process was ongoing.
And timely submitted by your count was, what was your cutoff, 30 days or?
Right. The court in the OSC matter 170128 had ordered that the department submit all appeals within all currently filed appeals within 30 days of their filing, and the department had in fact done that for the bulk of or not the bulk, but many of the cases on the court's chart. So the delayed appeals are only the ones that were submitted 30 days or longer than 30 days after after they were received by the department, by the Appellate Services Administration.
360 is still a fairly...
It's still a lot, and I'm not trying to quibble to say that it's, I just wanted to correct that minor factual error. It's still a lot of cases. It still was an egregious, issue. The elements of procedural due process, however, are notice and an opportunity to be heard at a reasonable time on the issue. This case differs from the usual cases and the ones cited in the briefs alleging that a governmental agency has violated a claimant's due process rights, because here there is no allegation whatsoever of any unreasonable delay in obtaining an actual hearing on the merits of the claim, or even in obtaining the agency-level appellate review. No one has even alleged that those agency-level processes were inadequate or violated the claimant's due process.
Let's stop there, though. And I do want to actually talk to you about the structure of the agency process, but that's a separate issue. If the Superior Court fails to transmit records, fails to inform this court of its judgments, and essentially frustrates the right of the people to appeal, has it afforded due process merely by the fact that it has timely held a trial?
Well, that's a good question, Your Honor, and nobody has submitted any cases that actually...
Isn't the answer obviously no? I mean, we've had a situation in the past, the distant past, thankfully, where that actually happened in the Superior Court, and I don't think anybody argued that it was just fine that the records were hidden. That's not due process.
Right, and I'm certainly not arguing that that was absolutely fine or anything of the nature. And I also do, however, think that there is a difference between an appeal as of right from a Superior Court trial versus the discretionary review at issue here, much like discretionary review to the Arizona Supreme Court or petitions for cert to the U.S. Supreme Court, where the person doesn't have an actual right to be heard. They have a right to consider that application.
Wait a minute. I understand it's a discretionary review, but are you really saying that the applicants are not entitled to a timely evaluation of
I'm not saying that at all.
Process?
I'm not saying that at all. But what I am saying is that because of the different certainty of the right involved, the difference in the amount of process that has already occurred and the discretionary nature of the process remaining, that the delay is one factor. The fact that they might have been deprived of this discretionary review is another factor. It's just part of the weighing process.
That
in other words,
though, an attitude about the process that sort of infects this entire proceeding, and that is that because most of these appeals don't get heard on discretionary review, the discretionary review is a minor part of due process. One could say the exact same thing about the Supreme Court of Arizona or the Supreme Court of the United States, yet I suspect that most people view those courts as very important to their rights. I can't imagine that the state's position in this case hinges on the fact that review here is unlikely to succeed and therefore not that important.
what I'm trying to say, if you look at the cases that have been cited in the briefs, the courts tend to find that shorter delays violate due process if it occurs before the person has even had a hearing. And then longer delays, 19 months, 2 years, even, over 2 years, have been held not to be substantial enough to violate due process when you're talking about review after an evidentiary hearing has been held.
Let me ask you this for my own knowledge. If the result of the agency review is a determination that there was an overpayment, and the beneficiary of whichever type of benefits we're talking about seeks appellate review in this court, when do collection proceedings begin?
Well,
Begin before this court has issued its determination?
my understanding is that there is a 6-month grace period where the person is not subject to paying interest on the overpayments.
But the principal.
But the principal remains there as a debt.
So
and
while the appeal is sitting in a drawer and we are unaware of it, the department is out there collecting an overpayment that may get reversed.
Well, they haven't in this case, and in fact, they have waived the interest on those overpayments, so they're not even attempting to collect.
But how did it know that? How do you know that the department hadn't? Because if the appeals weren't being transmitted, and the department had made a determination of overpayment, and the department, according to the state's position, was unaware for quite some time that the appeals hadn't been transmitted, what's to stop it from going out and collecting those overpayments before they've even been ruled on?
Well, as the chart reveals, most of the claimants did not in fact pay their overpayments. The interest was accruing. The department has now waived that interest. The few people that did repay the overpayments, if it is determined that they shouldn't have, it's not an overpayment after all. In other words, they win on appeal, the department would, of course, refund that money. But if it is upheld on appeal, then they paid the debt that they owed. And again, the department has even issued refund checks for people who paid interest, but because they had a delayed appeal, that would have been waived had they not paid it. They have sent refund checks to those people.
And that's good. That's a good step. But we're talking really now just about the due process violation itself, not the remedy. And my point is, if people are subject to collection efforts during the time that their appeals are being hidden, then how can we say that that's not a due process violation? They're experiencing actual harm that is protracted, and their last chance of avoiding that harm is this court.
Well, again, Your Honor, the problem that we have in this case is that none of the actual appellants are before the court. We have these pro bono attorneys that have been assigned to draft sort of in the abstract whether a due process violation occurred. I don't know, frankly, whether anyone on that list was subject to actual collection activities other than perhaps a notice being sent out, hey, this is how much you owe. There are no facts before this court, and that highlights the problem with trying to decide in the abstract this due process issue rather than taking it on a case-by-case basis. If somebody were to come before the court and say, here is this horrible thing that happened, you know, I submitted my appeal application and they collected all the money and you know, years have gone by and my application has never been heard, that's a very different case from someone whose appeal was delayed by 3 days and was never subject to any kind of collection activities. And those factors do weigh in the evaluation of whether their due process rights.
Well, in your view, how much of a delay would implicate due process? A year?
Well, you know, Your Honor, in
Well, what's
many
the
cases,
state's position?
the state's position is that the delay that occurred in this case, in almost all of the cases, did not result in a due process violation. It's not only a time factor, Your Honor. Cases have held that delays as long as 3 years do not violate due process, and that's what we're looking at here.
So
but the department,
is it nothing beyond 3? Is it nothing short of 3 years? What's
the department's position is that we can't, in the abstract, decide on just a cutoff date because the time factor is only one of the factors under Matthews v.
How about intentional
Aldridge.
wrongdoing? Can we say that when a government actor intentionally interferes with someone's legal rights, that that's a due process violation?
Right. And almost out of time, so I'm going to try to reserve 10 minutes for my co-counsel. But, Your Honor.
I'll ask our presiding judge to give you a little bit more time.
Okay, thank you. Your Honor, there was intentional conduct on the part of the employee to not do her job. But it doesn't seem to me, based on the facts that are before the court, that there was intentional conduct by this employee to actually harm particular claimants or appellants or whatever. And there certainly was no intentional conduct on the part of the agency as a whole. The agency as a whole, when it learned of this, was appalled, distressed, as horrified as the court, and took immediate steps to fix it. There's no indication that it was
immediate steps. We wouldn't have the decision that came out of the other OSC panel.
Well, and as the court noted in that case, they did timely transmit lots of them, but on the day that they were due, they found a lot more applications. They tried to submit them timely. There were just so many, they couldn't do it. And they tried. So
let me put it in a different context then. I mean, what I'm hearing from you is that there might be a no harm, no foul defense. Right? If they were going to lose anyway, then who cares if they lost later? And that to me is troublesome, especially when we know very well that intentional misconduct by government actors can, over the course of a mere couple of minutes, can constitute a due process violation. If somebody is wrongly incarcerated, for example, because of intentional misconduct, and they're only wrongly incarcerated for moments, that's a due process violation. So if somebody is deprived of their right of access to a decision over property rights for years, can we really say that the standard is that elastic?
the standard does, though, vary depending on the facts of the case and what property interests were deprived, what rights were deprived by the alleged due process violation. And again, I think it's hard to draw a bright line rule about exactly how much time can pass.
What are the other factors then? We know, let's say we're talking about unemployment benefits, a person's wages, what a person used to buy food for herself and her family, and we're talking about an intentional delay by an unsupervised rogue employee. We're talking about a lack of attention by an agency that is set up to serve people like these claimants. So what else? What other factors, other than the delay, the particular delay, affects whether there's a violation of due process?
Well, again, you know, under Matthews v. Eldridge, you've sort of identified the factors, and to the extent that the court has, you know, decided that there is the private interest, for example, factor under Eldridge has to be applied in light of the generality of cases, not the rare exceptions. And what we have here is a situation for years and years, the department followed this procedure. They had an issue. They had these two computer systems that didn't talk to each other, and so it required an employee to take information off this computer system and enter it into that one in order for the appeal to happen. And they had a rogue employee who, for whatever reason, decided she didn't want to do that. The department agrees that that was awful. That employee's conduct with respect to the agency was definitely intentional. She intended not to do her job. But the agency itself had no intention to deprive people of their appeal rights. They had a process set up that was intended to facilitate these appeals.
You know, it was this court that noticed. It was this court that called the agency's attention to the fact that where were all these appeals? It's unfathomable to me that no one in the agency was checking some database to say what happened to all these cases. So I'm sorry. I know you're not the person.
I would like to answer that, if I may, actually, with all due respect, Your Honor. If the court reviews the transcript of the hearing, in the OSC hearing, the evidence presented at that hearing was that, in fact, the agency had started to discover these delayed appeals as well at right about the same time that the court did, and had itself brought to the court's attention the fact that many of these appeals had been delayed and that they would be filing them, and then continued to investigate and look for more and found more, and then looked in other places and found more, and then conducted an audit that went all the way back to 2012, which was before this employee had started working sometime in 2013. They went all the way back to the beginning of 2012 to ensure that, in fact, it was an issue about this employee and not a systemic problem in terms of the process that had been in place. And what they found...
Say there's no systemic problem. The agency set up a system that it knew involved two systems that wouldn't talk to each other. It knew that it took a single person to form that bridge. And apparently, if I can't infer anything else from what you're saying other than that the agency did absolutely no checking at all. about what happened to these cases. It keeps no statistics, apparently, on what the results are. It doesn't monitor whether the internal agency appellate process is being upheld or reversed. It doesn't track clearance rates. It doesn't do anything. That sounds to me like a complete absence of management.
Okay,
Am I wrong?
You might well be, Your Honor, and I hesitate to say that.
I hope I am.
But the problem in this case is that we don't have those facts before the court. My understanding, actually, of the process is that they did try to track some statistics. The computer systems had initially been designed so that they would talk to each other, but the legislature didn't fully fund, and this was all at the OSC hearing, if you would like to take judicial notice and listen to that hearing transcript, that the legislature didn't fully fund, and so it ended up that the computers didn't talk to each other. They didn't design this system. So then they implemented a procedure whereby an employee, actually a couple of employees, were responsible to make sure that this happened. The one employee sort of duped the other employee into not doing that portion of the job and said she would handle it, and then just didn't. The agency was as duped as anybody by this employee. And despite their efforts to supervise, she was hiding computer files in, wrong labeled files. She was literally hiding them in her office in other files with other names on them. It was pretty hard to detect. But once they did their audit, they really did discover that
it's easy to detect that there's nothing happening. That's my point. If I would think that at the Attorney General's office, if no briefs were filed for 6 months, somebody would notice, right? There must be some sort of tracking of that.
And you're right, Your Honor. That is correct. If none had been filed, it probably would have been noticed much sooner.
What do we have, 2? I mean, we had fewer than 5 cases filed.
Yes, and when it got to that stage, that's when people did take notice, both at the court and at DES. But the court's own chart in the OSC case that was attached to its decision shows that prior to the 2013, the cases basically were very low, and then they went up and hit a peak during the recession, and then they came back down, and they were very low again, sort of matching the pre-recession level of cases. And it wasn't until they dipped way below that people took notice. And so, again, I'm not, without any facts before this court to demonstrate exactly what happened or whether there was supervision going on that just, was adequate but not quite adequate or not, I think it's hard in the abstract to just say.
I've taken a lot of time, and I apologize for that, but I just have one very quick question. Is it the state's position that there was a due process violation or not?
In some cases, there likely was a due process violation, but not all.
Okay.
Thank you.
But you're not saying which ones?
Well, I do think that has to be addressed on a case-by-case basis and would be best addressed by the actual claimants who think that their due process rights have been violated.
Well, does the agency intend to call each of these individuals in or do an individual case analysis of this? I mean, most of these cases have already been disposed of in this court. We can't do that here.
No, and it does seem to me, Your Honor, with all due respect, that if an individual claimant feels that their due process rights have been violated, they can take whatever action and bring that claim.
So you're
or
inviting
if
those
the
people
court,
to file lawsuits against the state.
The ADES is doing its best to address any harm that's been caused to them because they don't want these people to have been harmed. And the idea, hopefully, is that they'll feel whole. That despite whatever delay happened, they haven't been harmed by it, and hopefully that will make everybody happy.
What would be the scenario in which a claimant whose appeal sat in that drawer for 2 years and recently was disposed of finally by this court? What would be the scenario in which that person would assert that her due process rights were violated?
And the other portion that I started to say, Your Honor, was that this court, if in any individual case feels that due process was violated in the claims that are perhaps the ones it grants appeal on that were substantially delayed, might order such briefing as pro bono attorneys suggested, appoint pro bono counsel to address that due process issue in those cases. But I don't believe that there was a due process violation in every case. The cases out there have a wide range of what is considered a due process violation in terms of delay. And some of these cases undoubtedly fall within the range of a potential due process violation, and others do not. But I don't think we have the factual record here in this case to address that.
In the overpayment cases, I mean, to me, that's the biggest issue. That's the elephant in the room here. got probably hundreds of people who owe large amounts of money for them, for anyone, particularly for them. And as I said before, they long ago spent that money. What could such a person do to assert, or what could such a person do, and how could such a person assert a violation of due process in that scenario?
Again, Your Honor, to the extent you're merely asking about the due process, I mean, they could take whatever appropriate action for filing a due process claim would exist. But in terms of solving the problem, I would point out two things. First of all, with the overpayments, an overpayment by definition means that they received money that they weren't eligible to receive. And sometimes that happened because of fraud, and sometimes that happened for administrative or other non-fraud reasons. And there are pretty strict federal rules. It's all federally funded. There are pretty strict federal rules about when a person can be entitled to a waiver of an overpayment, which the agency will look at those very closely. If somebody submits that application, they'll certainly consider them and grant them if possible, and certainly would consider that in each case as applied by the claimant. But to suggest sort of an overarching across-the-board remedy for every single person whose case has been delayed from anywhere from 2 days on up is, I think, overbroad, and that it does need to be a more case-by-case determination. The agency is willing to consider, any kinds of remedies that will help these people not to have been harmed for the harm that was caused by the delay. They don't want that. As you said, they are an agency charged with helping people in distress. It's what they do. It's what they want to do. It's why they were so distressed when they found out this had happened.
Okay.
They don't want this any more than the court does.
Okay, thank you.
Okay. And I would ask that the court allow my cohort to address her portion for at least a few minutes.
Exactly. What we propose is to give Ms. Salvati her 10 minutes, and then since we've gone way over, allow your pro bono counsel to another 10 minutes to divide as you wish. Be working on that in the meantime. So,
thank you very much, Your Honor.
if you feel like it would be worthwhile.
May it please the court. I'm Assistant Attorney General Carol Savati, co-counsel for ADS in this matter, and I will be addressing the remedies issue. And I would first like to go to the collection efforts issue that was raised by Judge Swan. It could be that the agency was collecting on some of these delayed appeal applications. But then the department's benefit processing unit identified which were the delayed appeals and then suspended all collection of those, all collection efforts in those cases while the appeals were pending.
Is that, I didn't detect that from the spreadsheet you filed. It's helpful information, but is that reflected on any document that's part of our record?
There is no record.
Well, part of the filings or submissions in this proceeding, I mean, you've given us a spreadsheet, an updated spreadsheet. I don't think we could glean what you just said from that spreadsheet.
That's correct. It's not included on the spreadsheet.
Perhaps I could augment Judge Johnson's request for an electronic submission with something to that effect, because that's important information you just gave us.
I will do that, Your Honor. And that the department has already implemented remedies, including the suspending of collection efforts, to eliminate or mitigate any harm that's been caused to the delayed appeal applicants. And the department, as soon as it was able, under the newly enacted statute, agreed to waive the interest on overpayments from the time of the determination of overpayment until this court decided the application.
Now, just to drill down on that a bit, I understand now something from reading your briefs that I didn't understand before, which is the the state may waive 100% of interest on non-fraud and administrative overpayments,
That's correct.
and is doing so,
That's correct, Your Honor.
but can waive only 25% of interest on fraud overpayments,
Yes, that's correct.
and that's by
Statute.
state law,
Pardon?
state law or federal?
It's state.
Okay. Okay.
Yes. And the department has been refunding the interest for those claimants who have already paid the interest on their overpayments, and those checks have been going out. The state also has conceded error wherever appropriate as quickly as possible so that the claimants can promptly receive the benefits that they receive if the decision did not go in their favor at the board, but when this court granted the application, and then we were able to pay out the benefits to these claimants.
I'm curious, in how many cases, because that's something I was unaware of, in how many cases has that occurred?
We have 2 cases, Espejo and Armadillo. Those 2 we conceded error in, and a different panel of this court has agreed with us. And so Espejo has already received her benefits, and Armadillo is or will be soon receiving her benefits.
How late were those appeals in those 2 cases?
I don't have that information.
Do you have at your fingertips the number of cases of the hundreds that we reviewed this year? How many we have granted the application for appeal?
I don't have that information.
Do you know offhand an estimate?
No, I don't.
A range? Okay.
I don't.
Just a follow-up question. Sorry to pepper you like this, but it sounded like you were saying that where this panel of this court has granted the application for appeal, that the department is moving forward and conceding error in each of those cases and intends to pay the benefits. Did I misunderstand you?
Oh, I'm sorry. I probably didn't. I probably wasn't clear on that. When we've received a brief and we review it, and at that time we'll decide whether it's appropriate to concede error or not. And of course, even in cases where the department concedes error, this court can make a different decision. But in at least 2 of these cases, the department conceded error, and a different panel of the court agreed with that decision.
Is it not the practice of the department to review appeals when they're filed with this court as soon as they're filed? Or is it the department's practice only to review those on the merits if this court accepts the appeal? In other words, from our standpoint, it's a very one-sided process. We get no participation from the department at this level unless we accept the appeal and put it back into the pipeline of normal civil appeals. I'm wondering if that reflects the fact that the department isn't reviewing such cases at all until it feels it has to, or does it review them for potential concessions of error as soon as appellate remedies are sought in this court?
If this court decides, if this court denies an application for appeal, we don't review it.
And you don't review it before this court denies an application for appeal?
That's correct.
Okay.
The pro bono attorneys have proposed certain remedies that would burden the department without giving a corresponding benefit to the delayed appeal applicants. Indefinitely keeping hearing recordings is creating a solution that is no longer for a problem that no longer exists. The department retains its hearing recordings for 3 years, and and sometimes later if that recording has been transcribed. But given that the panel in the OSC matter is overseeing the department's processing of applications through the department's monthly inventory and audit reports, and that the department is current in its processing of applications, then there's no need for the department to incur the added cost of retaining those recordings. The pro bono attorneys also...
The question I would have about that, though, is, well, I'm heartened to hear that the audits are currently showing that the department is current in its processing. The department thought it was current in its processing a couple of years ago, too. What if it's wrong? What is the harm of saving the recordings long enough to make sure that this has actually worked?
Well, the backlog of cases is now almost over, and
are we sure of that? I mean, I say that without any I don't know, accusation, but I really wonder if there was an active fraudster within the department concealing cases, how we can be certain that we've found them all at this date.
The department diligently looked through 12,000 records to find any appeal application. 12,000.
12,000 appeals or 12,000?
12,000 applications for appeals. And they've implemented various procedures that we've described in the procedures flowcharts that have been submitted in the OSC matter to show that every time that a problem is identified, then they find some mechanism to fix that. And for example, the department has what's called an open door policy, whereby applicants for different public benefits can submit them through certain portals. And one of these applications came through the Healthy Arizona portal. Well, that was something that the department had not anticipated. It took a little while for them to recognize what it was. But then the Appellate Services Administration amended its flowchart to put a mechanism in place so those would be accepted.
Right. What your brief acknowledges the possibility that in the relatively small number of cases in which this court will grant an application for appeal of the small number of these delayed cases, those claimants may be entitled to a remedy for the violation of their due process rights. What do you propose along those lines? How can those remedies be afforded, and what sort of remedy do you think would be appropriate?
I think the most important remedy was the waiver of the interest, because when a claimant receives benefits to which that claimant is not entitled, the law requires that is paid back. And what the department has done is to waive the interest so that they're not put in a worse position over the length of time it took for their case to be decided. And that has a large financial impact.
What about the cases, though, in which the application for appeal is granted in cases where a claimant should have been receiving benefits but did not?
Yes. Now, those are the cases where we quickly determine whether it's appropriate to concede error.
Okay. What other? Your brief seemed to suggest that in that category of cases, those claimants may be entitled to a remedy other than their benefits in recognition of the violation of their due process rights as a result of the delay. What kind of a remedy would you suggest, and how would you suggest it be implemented?
Well, the department hasn't authorized any other remedy in that kind of situation, but the department is, if the department is presented with an individual claimant's circumstances who has alleged definite harm from the delay in processing, then the department will look at all the remedies possible, and we'll have to investigate remedies possible to perhaps compensate that person further.
Okay.
Are there any other questions?
No.
Okay, thank
you very much. Ms. Falgout, did you have some?
You had a couple of questions about the chart, and I would be happy to give you a couple of numbers if you're interested still.
If you're going to speak, you should probably go to the microphone.
Thank you. I wasn't sure if you were going to want me to. You had asked about the Espejo and Armadillo cases. You can look at those. Espejo is at line at 102, and Armadillo is at line 215 on the chart. And I just did a quick count of the number that had been accepted for review as of the date that the court submitted its chart to us of September 29, 2017. I counted 21. Could be off one way or another by a couple, but that's approximately accurate.
Thank you.
Thank you.
All right.
Just very quickly, Your Honor, you addressed or you brought up this kind of elephant in the room of overpayment, and under ARS 23787C, if a claimant appeals the overpayment determination, the adjudicator at the department has to consider a number of factors. And we would urge the court to direct that adjudicator at the department consider delay in the appeal, and also consider reliance factors. Maybe that goes in with the delay factors, but at least the policy at the department level for what factors to consider when waiving principal amount.
Presumably, you're talking only about non-fraud cases?
That's under the statute only. It has to be the administrative.
It would be anomalous to give people money back that they've obtained by fraud.
Correct.
Okay.
Correct. So at least in the administrative cases, to direct that the adjudicator at the department level considers delay when waiving the principal amount. That's what we would suggest, Your Honor.
And you change position, that would have
Correct.
occurred.
Some type of reliance, how long this person relied on having that money, and in addition to financial considerations and the things that the department already considers in waiving the principal amount.
Thanks.
Thank you.
Your Honor, may I just,
1 second. Is there anything further? I guess I have a question for on the remedy section. In the 20 or so cases that the court has granted an application for appeal, in whatever subset of those cases, where it turns out that the claimant was wrongly deprived of benefits to which the claimant was entitled, what sort of a remedy, what sort of an additional remedy would you suggest would be appropriate to be granted as a result of the violation of due process, and how would you suggest that happen?
Your Honor, I think as I sit here now, having been asked the question, I would want to think about it more were I representing one of those individuals to be a little more, to be creative about what might happen under the facts of that particular case, because I think that it may differ. At a minimum, I think that, that statutory interest, at the very least, should be ordered paid on the whatever benefits the person was deprived of, and there could be a sort of lodestar adjustment on that if there are aggravating factors in the case of a particular claimant. How we get there, I think, is what I suggested earlier, and what I don't think the department disagrees with, which is in that subset of cases, utilizing the strength of the bench and the bar, as it were, here, to appoint pro bono counsel in those cases, so that those claimants who are otherwise unrepresented, I think in all cases, or nearly all cases, have the some expertise and some representation. As we're finding out in all these administrative settings lately in studies that are being done, the likelihood of success increases greatly, and at least there's more of an opportunity for that, for those claimants to be heard, and for the individual panels considering those cases to determine what beyond statutory interest might be acceptable vis-a-vis a remedy that is suitable under those circumstances.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
I just wanted to clear up that in order to apply for a waiver of the recoupment of the overpayment has to be classified as administrative. And the department has...
So not non-fraud.
Not non-fraud.
But there
It must
three
be...
classifications, right?
Yes, it must be administrative to be considered for a waiver for recoupment of the overpayment. And the department does have a substantive policy statement that defines the factors that will be looked at. And that was all. Thank you.
Thank you. All right. Thank you to all of you for your briefing and for the extended argument. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.